Let me begin by just saying, if I could accurately predict the future, I'd probably be a stockbroker rather than practicing law. But that's just the uncertainty that we all have right now. What we have tried to do is to look at some topics that we've been receiving some calls about, and try to cover a few of those, and just give everyone at least our thoughts about what may happen. The first topic that we thought we'd talk just a little bit, and what Mike and I are going to do is kind of just play this off each other, and just discuss these topics, or what's the risk that my business or customer may sue me if a person comes onto my place of business and alleges that they have gotten COVID-19 at there. What can I do to protect myself? And is there potential insurance coverage that you may already have, or if you don't, you ought to be at least looking into? I will say this, at least in my opinion, I don't believe that there's going to be this wave of litigation where lawyers are going to be representing clients who say, I visited this particular business and I caught COVID-19 while I was there. I think, number one, it's going to be very difficult to prove. I've had some experience in litigating cases involving foodborne illnesses before, particularly from restaurants and so forth, and those get very difficult to prove. You've got you've got so many people in the community now who either have had COVID-19. It's going to be difficult to say and to prove in court that I contracted the virus when I visited this particular business or this particular establishment. But there are things that I think you should do to protect yourself. And I'll also say this: while there may not be the wave of litigation that we're talking about, that doesn't mean that some client or some lawyer sometime may try to pursue that kind of a claim. But nonetheless, there's some things that I think that all businesses should at least consider. Number one, the governor's office have put out recommendations for reopening businesses. I think you ought to look at those. You ought to know what those provide for your particular business, and to the extent that you can, try to make sure that you have complied to the best you can. Is that an absolute defense? Will that provide absolute protection? No. Anybody can file a lawsuit alleging anything they want at any time, but that should protect you, at least in showing that you have acted in a reasonable type manner. You ought to look at those, and to the extent that you can, try to follow those as they apply to your business. The other thing that I think you've got to be concerned about is your insurance coverage. Most businesses have what's called a commercial general liability policy, or CGL coverage. I think it's important to be sure that you have this type of coverage. If you do get such a claim, you need to remember that your insurance coverage does two things. One, it will provide you, and this is usually the thing that's the most important, provides you with a lawyer or with a defense to those claims. And secondly, in the event that you're found liable, it should indemnify you, given the fact that if it's within the policy period and the terms of the policy, it should indemnify you up to the terms of your liability coverage. So bottom line is, try to be reasonable. Don't be overly concerned. Follow the governor's guidelines to the extent that you can. And finally, make sure you have the appropriate insurance coverage for these, and that's generally liability coverage. Mike, been a lot of people talking about employees. Why don't you tell us about what if you have employees who would rather draw unemployment than come back to work?
Thanks, Buzz. One of the things that, let me comment on one thing Buzz said too, that is in terms of your insurance coverage, there's a big dispute about whether coverage for COVID-19 is covered under some of the policies. Obviously, the insurance carriers would take the position that it's not covered. Clients will take the position that it is covered. You may want to be checking with your agent because you want to have that coverage in place without dispute if you can. That's easier said than done, but it is important because I think there will be some disputes about whether there's any coverage for this event at all. Let's talk about employees returning to work. As you know, under the emergency regulations and the statutes passed by Congress under the Coronavirus Response Act, the employees who are laid off or furloughed are not only receiving their normal unemployment pay, but they're also getting $600 a week. And they get that if they're still laid off up until the end of July. So in many instances, an employee, particularly probably in this part of the country, is receiving more in unemployment than he or she was earning on the job. So there, you've got to anticipate that some people don't want to come back to work. And what can you do about it? Well, the first thing you need to do is, if you're at the point that you're starting to bring folks back, you need to have a notice of recall. There's documents that we have that we're happy to share, or that others have. In other words, a written notice to the employee when they're to report back to work, when they're to report to their supervisor, and when the information is effective for their purposes. That is, that if an employee doesn't come back to work on the day that he or she is scheduled, you want to treat it as a job abandonment and a refusal to recall. And you want to report that to the Unemployment Insurance Commission, because that will terminate unemployment benefits in a normal situation. So first, you want to send out a notice of recall. Then you have to face the issue that there may be some employees who can legitimately claim that they could not return to work, either because they're in a high risk category, there's still no home health care, there's no child care available yet. I think it's opening up, but it's not available today, and that they have fear of contracting the virus. You're going to have to handle those matters sensitively, because you cannot just arbitrarily say, no, that doesn't apply. It's very fact specific. And so if you have a situation where an employee is not returning to work simply because of a fear of developing the COVID-19 virus, that's not a valid concern. However, if they fall within one of the categories that are enumerated in the Act, it may be. So I can't do more than just generalize about that today. So my advice is, one, if you're in the position to recall people to work, go ahead and send out the notice of recall. Be sure that they understand if they do not come back to work, they'll be treated as if having abandoned their job. And then what would occur once they abandon their job in terms of the unemployment benefits they're currently receiving. Now, I will say this, as you probably know from all the governor's press conferences, the amount of unemployment claims that have been filed in Kentucky and nationwide are just astronomical. And it's taken weeks and weeks just to work through the system to get folks on the rolls. I think that's largely accomplished now. And now people should be coming off the rolls as employers are starting to open up following the governor's guidelines, as Buzz has indicated. So if you're going to bring people back to work, then you have to think about, okay, how can I do that safely? For any of the organizations that may be participating that have members of SHRM, the Society for Human Resource Management, SHRM has some excellent guides for returning people to work, and I recommend those. They're something we use quite frequently. You know, what you can do about screening. Can you ask people about symptoms? Generally speaking, in the normal environment, you can't really inquire about someone's health condition. But in this situation, both OSHA and the CDC have said you can, at least to some extent. You may take body temperatures, and many employers are doing that as they come back to work. You may ask if they have had a fever for 3 days without taking medication. You can ask what respiratory symptoms they have. So there is a way to inquire. And then you have to be careful, though, if you discover that this employee, John Doe, let's say, has symptoms and you send him home, then you need to talk to the other employees, but you cannot identify John Doe, the other employees with whom John Doe had contact, but you can't identify him by name, and that gets you into some privacy issues. So can you force employees to return back to work? Probably, with a few exceptions. Do so carefully and be cautious in your approach, because otherwise you may well wind up in one of those lawsuits that we've talked about. Buzz, what about contract?
Hey, Mike, I have a question that came through real quick.
Yes.
Okay, so we had someone ask, would employees transitioning from work from home back to the office work require the same stipulations as those who have been furloughed, such as the written notice of recall?
Yeah, if they've been working from home, telecommuting, they've probably never been furloughed. So they really can come back to work without the same recall issues. On the other hand, in terms of checking their temperature or checking for symptoms, I think that is accepted and wise to do, because you don't know. You can be negative one day and positive the next. Just look at Vice President Pence's press secretary. So I think that you can inquire, but I don't think it's a recall in the true sense, because they've been telecommuting up to then, presumably. Now, let's talk just a little bit about telecommuting. That was done a lot. We've done it here at this office a lot. We have about half our staff come in one day and half comes in the next. And when they're not here, they're telecommuting from home. Not as efficient, but it does work, and it's been beneficial. But you have to track that work. You can't just, you can, but I don't recommend you just say, go do whatever you feel like doing, because they may not feel like working for you. So I think that you have to be careful about how you handle telecommuting. You must pay them just as you would pay them at work. They're entitled to the same breaks that they get at work. They're entitled to the same work hours. But in terms of returning from telecommuting back to the office or the plant, I think in that situation, you may ask the screening questions, but it's not truly a return from furlough.
Thank you.
I'm going to talk for a second about contracts. I know that many of you probably have agreements with suppliers, or that you've entered into with other businesses that have certain terms that quite frankly are just the circumstances have changed so much that what that contract says, or one party is supposed to do, or the other party is supposed to do, it simply has not been able to be performed. And what are the obligations of your business in those kinds of situations? A couple of things to keep in mind. First of all, you need to get the document out and look at it and go over it. There are many contracts that have what's known as a force majeure provision in that, which say that basically if it's an act of God, circumstances such as what we did, that contract may not be enforceable. There are also provisions in contracts that have language that say if it's impossible for either party to comply, they may not be enforceable. Again, you have to look at the actual document and see what what it says. The world has been turned upside down, basically. Things have changed. If you've got an agreement and somebody's either not paying or you're unable to pay, what's the best way to deal with that? What's the way to handle those kinds of situations? Couple things that I'll just say about that. First of all, business disputes are best resolved by business people trying to find a common ground that everybody can live with. By that, I would suggest that you try to work it out with whomever it is that you're dealing with to see if there is a mutual way that you can work out that difference. I'm speaking in generalities now, and it's kind of hard to talk about specifics. The other thing that I would strongly encourage you to do is that if you do have a provision that you both agree to, that you're going to suspend payments or that you're going to accept late shipment, those kinds of things, document those changes. Many times we have end up litigating lots of cases where people have reached oral agreements and it's not real clear what that agreement was. One party will say, I remember it this way. Another party will say, I remember something different. A good practice to follow and to keep those is to follow those modifications up with an email or other letter or some other document that you can go back to and say, here is what we agreed to. If you have a telephone conversation with somebody and say, yeah, I'll give you some more time on payment or something along that lines, confirm with an email, simply a simple email. This is to confirm our agreement that we reach on the telephone on such and such day, and then spell out what that agreement is. I think when the court, you also need to remember that the courts have been basically closed except for emergency type hearings for the past couple of months. They are reopening, but the justice system is, as we like to say, sometimes the wheels turn very slowly. Well, it's going to be a little bit more delayed because of the fact that there have been so many matters that have been put on hold for so long. So the idea of getting into court and getting some kind of resolution from a court or a judge is going to be something that's going to take some time. You're going to need to recognize that and to try to take that into consideration. If you got a contract and you need to modify it, it's okay. Of course, you will be able to do it, but just try to confirm that in writing. Mike, have you got any thoughts on that?
No, I echo what Buzz has said. One of the things that's not exactly on point there, but I failed to mention a moment ago, it has not to do with the furlough issues as much as it does pay practices, because there's a big distinction between employees who are exempt from the wage and hour purposes or the Act and those who are non-exempt. Sometimes employers refer to them as salaried or hourly. That's not really the test. It's not whether you're paid salaried or whether you're paid hourly. It's the duties of the position. But the thing that's really important to remember is that if you have an exempt employee, that is someone who is in a supervisory position that is not subject to the overtime pay requirements of the wage and hour laws, that person must be paid in full for any week in which he or she works any portion of the week. So if they work one day and they're out 4 days because you don't have the work, you got to pay them. Now, that's not true of non-exempt employees. Non-exempt employees only have to be paid for the time they actually work. But we find that to be a real problem in that many times during this last couple of months, employers have simply not had enough work to keep their exempt staff fully occupied. And there's 2 or 3 ways to address that. One is if they're off taking PTO time that you have available, that's acceptable. But if you don't have PTO time available and they're off work, but they've worked part of a week, they have to be paid the entire week. You can reduce their pay as long as they meet the $684 federal minimum per week. Or you can, in a drastic situation, reclassify exempt employees to non-exempt status in advance. You can't do it retroactively. And if you do it in advance, then you can pay that person on a non-exempt basis and only pay them for the hours they actually work. It's amazing how often that comes up. We've had many clients who have faced that issue, and they cannot understand why they can't just tell the exempt employee to go home. They can, but they got to pay them. And they don't accept that, or they don't want to hear it, but they have to accept it. So it's an important distinction. The thing that I didn't touch on that was in some of the outline that was shared with the audience, back on the litigation question, is an employee going to have a claim against his or her employer for getting sick? The answer, like Buzz indicated, if a vendor or a customer comes in and says they contracted the virus at work, very hard to prove, because it's very hard to prove where the virus was contracted. But I will say this, that an employee might be able to pursue a workers' compensation claim if they can actually prove that they got the virus from contacts at work. They might not. Again, the insurance carriers are going to have a lot to say about that, but it is a possibility. But it's not going to expose the employer to liability from employee suits. Now, that's not customer suits, but from employee suits, because workers' compensation is going to be the exclusive remedy. And I should have mentioned that earlier, and I just forgot to. Buzz?
Mike, let me ask you, what if you're in a business and say you have 5 employees, all within a particular area that test positive for COVID-19, what do you anticipate would be the response of workers' compensation employees or workers' compensation insurance carriers to those kinds of claims?
I think, Buzz, is probably going to depend on how exact that contact tracing is. I mean, that we hear a lot about contact tracing, and where they try to go back and figure where someone got the infection to begin with. So I think if there's a fairly good record of John contracting it from Sam, then John may, and Sam was working with John, there may be a better claim for comp. I do think workers' comp carriers, being insurance companies, are likely to contend that there is not any connection, and they could have gotten it at the swimming party that weekend, which they could have. So I think it's going to depend, it'd be fact specific, but what I do anticipate is workers' comp carriers will probably deny most of those claims at the beginning, because they don't want to set a precedent of accepting them. And it's probably going to take some amount of litigation to clear that up to some extent.
Sorry, I'm trying to get unmuted. Can I go ahead and insert a question real quick?
Of course.
We've got one that says, in a small organization, it is very difficult to not identify or identity an employee that is being sent for testing or already tested. How do you advise the employer to handle staff notifications while staying true to HIPAA regulations?
That's an excellent question. You probably have to anticipate that in a small organization, the staff will know who it is who's gone for testing. The only thing you can really do is not identify that person, either by sex or by age or position, or certainly by name. Does that guarantee that the staff won't know? Probably not. The staff probably will know who it is. But all the employer can do is take the steps that it can reasonably take to ensure compliance with HIPAA. And that's all they can do. And if the employees want to guess who it is and they guess correctly, so be it. There's not much you can do.
Thank you.
Karen, feel free to interrupt if you have other questions. That's fine.
Okay, there is one other question I'll go ahead and address while it's here. It asks, what about volunteers with a charitable organization? What can you do to cover the organization from lawsuit from volunteers saying they got the infection from volunteer work they did with the charity? I guess it's somewhat like what you're speaking of with a small business or any business.
Yeah,
Well,
I don't know that I don't know that there's really any different standard. The volunteer who says, that he or she volunteered at United Way and contracted the virus there would have the same burden of proof of proving they got it there than that they got it somewhere else. And even if they could prove they were exposed at United Way, they'd have to prove that United Way in that hypothetical was negligent, did not take the steps it should have taken. And they might be able to prove that if, in fact, they didn't take the appropriate steps to sanitize the conditions of the workplace and to put into effect protocols that ensured or tried to ensure the safety. I remember when we first, started coming back to work and bringing people back, and I was told I had to wear a mask. And I said, "You mean I got to wear a mask if I go get a cup of coffee?" And our firm administrator said, "Yep." And I swallowed hard and did it. But you've got to put those protocols in place because if you don't, then you could have some exposure. But I think if an employer, whether it's a volunteer organization or some other, has appropriate protocols in place, they run less chance of being held liable for any kind of contracted virus.
And the other thing that I would strongly suggest that those types of organizations do is check with their insurance agent to make sure that they have the appropriate kind of coverage in the event that such a claim is made. It's not-for-profit agencies can get the same kind of liability coverage and other coverage that businesses can purchase. Yes, it's expensive. It's not that expensive, but there is a cost to it. But it is, in my opinion, and someone who serves on many of these volunteer boards and those kinds of things, insurance coverage is one of the most important things that you can have for volunteer organizations because that protects the assets and so forth of whatever the organization is trying to accomplish. Many of those policies may have a provision in there automatically some medical expenses. That's a common provision in many liability policies is that they will volunteer, they will pay up to X $1,000s of medical expenses, regardless of whether they're liable or not, with the idea that it's just easier to do that than to have to fight the claim in court. But you, regardless of whether you're a professional, a business that's in the public or not for profit, you need to make sure that you've got the appropriate insurance coverage to protect it. Let's talk for a second and just to change what should you do if someone is threatening litigation, or you get one of those dreaded letters from a lawyer saying we're going to sue you for this because of the fact that our client contracted COVID-19 at your place of business. Mike, what would you advise?
Well, first thing I would do is you would hope that you have put in place some safety protocols along the lines of the governor's recommendations and guidelines, along the lines of the CDC recommendations and guidelines. And let me say this to Karen. Karen, I don't know if it's helpful or not. There's a document, 4 or 5 pages, a back to work checklist, which if it's any benefit, I could email it to you and you can do what you want to with it in terms of distribution. Would that help?
I've got the one that's the 10 from the governor posted on our website. It's 10 healthy habits or something.
That's not, yes, that is true. That's a good one. This is actually from SHRM again. and it's
Okay.
it's for employers specifically. But the thing back to Buzz's question is, you want to have taken those steps to hopefully immunize yourself from liability before you get that letter from the lawyer saying that they're going to sue you. If you haven't done any of the things that the governor recommends or the CDC recommends or the SHRM recommends, then you do have some real exposure. And I will say this, it's hard to follow the guidelines because I keep getting them back in mid-March and through mid-April. I was getting, and I guess Buzz was too, 6 or 7 emails a day with guidelines. And one of them, the last one I saw from CDC, had 88 questions to be answered about your place. And it's very difficult to do. Now, if you have followed the guidelines or you've tried to, you get that letter, first 2 things you want to do. You want to be in touch with your liability insurance carrier, whoever that is, your insurance agent, probably, if you have an independent agent. And you want to be in touch with your firm's attorney, whoever that is, because you don't want to respond to that letter without getting proper advice. And proper advice may depend entirely upon what steps you have taken and what the letter is alleging, whether it's a customer, a vendor, an employee, or whatever. First, follow the guidelines. Try to have good safety precautions, protocols in place. Notify your insurance agent, notify your attorney.
You know, I think there's I was in a retail establishment yesterday, just picking up something, and a lot of times our employees are faced with very difficult kinds of situations. What if a customer comes in and wants services and refuses to wear a mask? What if we've seen news reports of employees getting in disputes with customers and so forth? What are the obligations of the businesses under those circumstances? I thought yesterday the situation I observed was handled perfectly. The employees who were waiting on the customer told the customer that it's our practice that you've got to wear a mask. The person said, well, I don't agree with that. What should I do? And what the employee told the customer was, if you will wait outside, here's our number. You can call us and tell us what you want. We will get it for you and bring it out to you outside. If you don't want to wear a mask while you're in our place of business, and I thought that was a fantastic way to handle it. And I anticipate that there's going to be some blowback from customers. So there are going to be some people who come in and say, it's just not what, I don't want to wear a mask. It's kind of becoming unfortunately, a political statement as to whether you wear one or not. But I think that it's, particularly if you're a retail establishment, that it's important to train your employees and have a policy and procedure for handling those situations. Mike, you got anything to add that you want to?
No, I think that's excellent. I do think this. I mean, I'll tell you what we do. We tell people we want them to wear a mask, but I'm going to tell you, if a client of ours says, I'm not wearing your damn mask, we're going to service the client without the mask. But we're not going to encourage it.
But we also are going to try to find a way to do that protects everybody. And it may be that we put them in a larger conference room or meet with them in the parking lot in the car or something like that, as opposed to just coming on in and sitting down and doing those kinds of things.
Hey, Karen, let me ask you this. In Logan County and in your area, are people starting to return to the new normal, whatever that means? And are people starting to come back to work and starting to shop and eat out a little bit?
It seems that way. The roads are getting fuller. You just noticed, it was almost like a month ago, it was like a snow day. You really didn't see a lot of cars out, but I've been out some and just noticed that the cars, I mean, there's a lot of people out on the roads, I guess is what I'm getting at. The businesses are trying to open back up, and then, I've seen different posts and stuff on Facebook trying to follow them, but I mean, it's very difficult. I see people trying to make decisions based on the safety of the people, and then you've got the people that want to return back to normal faster than the business is willing to do. So I'm just encouraging everybody to be patient, and that they're making the best decision that they can make for their business and the customers, and that's the best I can do. So
I think you're seeing about what we're seeing, 25 miles up the road. Yeah.
yeah.
What might be the best thing now, if there are any questions, let's just open it up and be happy to answer any
One question I had a question, guys. I wasn't really sure what the difference between an exempt employee and a non-exempt employee was. That the amount of money that they make that makes that, or?
Yeah, it's a good question. It's a good question, Karen. Here's the test. There's a streamlined test. You must make at least $684 a week, but it has to do with whether you are exercising supervisory, administrative, or professional responsibilities. For example, an artist may be a professional and exempt from wage and hour purposes. An accountant may be a professional and exempt from wage and hour purposes. A supervisor in the factory may be exempt. But just because someone is salaried, and we see that a lot, that does not mean they're exempt. It's a duties test. So you must look at the duties, and the Fair Labor Standards Act puts out on and a good guide too. If you go to the Department of Labor website, they'll have a test for exemption for any of those categories: administrative, professional, or supervisory. And that is the determining factor, not what the person's title is. It's what they actually do day to day. If they're not exempt, then of course they only have to be paid for the hours they actually work. If they're exempt, they must be paid for the entire week if they work any part of the week, or you lose the exemption status. And so that's really the key. So you have to look at the duties test, and there again, the easiest place to look, and pretty damn good guidance, is the wage and hour section of the Labor Standards Act.
Thank you. I've got one additional question. Want to make sure we can, I believe this is the same thing you may have been referring to, the steps to reopen, but they were mentioned the copy of the SHRM 10 steps to open up.
Yeah.
Is that what you were? Okay.
Yeah.
Would you mind emailing that to me, or giving it to Mandy? She can pass it along, and then I'll make sure. Guys, if you want to copy that, just pop me an email. I think most of you on the call have my email address, and I'll be glad to forward it over.
Yeah, it's like 4 pages. It's pretty good guideline from SHRM. I think it's one we use. I mean, it goes through the normal things you'd think of, but it's detailed. It's in outline form, and it tells you how to meet safety measures, how to meet the protocols that are designed. So I would recommend somebody look at it if you're in that process. I would ask this: are most of our employers starting to open up a little bit and bring people back? Are the furloughs ending? Are you having any problems with people who say, I'm not coming back to work, I like this unemployment too well? Any of those kinds of issues that you're aware of, Karen, or anybody on the call?
No, not that I'm aware of, as far as that they've contacted me. So I'm not sure. We have a separate economic development area, department that shares the building with us. So they may have a little bit more with industry, but I haven't heard anything yet.
Okay.
And I think the message is out there about what y'all are saying, that if people refuse to come back to work, they're going to lose their unemployment. I've heard that before. So it's not, I think that message is starting to get out.
Yeah, that's true.
So one question: if you lay off an employee and then it is determined that they are unable to return, if they have earned bonuses, are you required to pay those out?
That is a really good question. Here's the reason it's a difficult question to answer. It depends on what the practice and the policy of the company has been in the past. In some companies, if you have earned time, like PTO time or bonuses, and you leave, you don't get to get paid out. In other companies, there's a practice and a policy of paying them out. You have to follow, you can't make a distinction because it's COVID-19. So if in fact you've earned that time, and the practice has been to pay that out, such as accrued vacation, that sort of thing. Now you're asking, or the question really is addressing the question of bonus earned. On the bonus question, it's a little different. Most of the case authority has said that if in fact a bonus was earned and then you change the rules, you can only change the rules going forward. So if it was earned and the practice had been to pay the bonuses and people left, you had to continue the practice. But but you can change the practice going forward, but it's not for bonuses already earned. It's only for the practice going forward. So it's a little complex depending on the company's policies and the practice of the company. But generally speaking, whatever you did in the past, you have to continue to do.
And I just had a question that kind of popped up after thinking about, are businesses required to send in their plan in order to reopen to the governor's office, or does it depend on this, or do you know that?
I'm not aware of any obligation of the individual business to do it. I know that Restaurant Association has gotten with the governor's office and come up with a plan. I know that there are other groups, but I don't know, unless Buzz does, of any obligation of an individual business to submit an individual plan to reopen. Are you aware, Buzz, of anything like that?
I have not heard of any requirement that a business has to send in a plan to the governor in order to reopen.
Okay.
Yeah.
I would suggest that in order that a good practice to follow is to document what your plan is and to try to have something typed out, or at least to memorialize what you have done and how you're going about it, and then follow it.
Mm-hmm.
I agree. Mike, a question I had, we've talked about coming back to work and so forth. Give us some examples of what are legitimate excuses for someone not to come back to work versus someone who may not be a good reason not to come back to work.
Well, obviously, one of the ones that is outlined specifically in the federal legislation has to do with an employee who has no daycare available, and daycare is just now opening up, and so if you have children who are in daycare, that may be a valid excuse. If you're caring for someone who is symptomatic, that's a valid excuse. I think the test really comes down, if you're just afraid that you will be exposed and develop COVID-19, that is not a valid excuse. So it has to be based on one of the criteria set out in the federal statute that prevents you or entitles you to extended sick pay under the federal law. But that is fairly limited, and just being afraid to come back to work is not sufficient. Now, what you can find, of course, is people can come up with reasons why they document their fear, such as they contend they have symptoms, they contend they've gone for a diagnosis. And in some of those instances, they may be legitimate and it may be appropriate, and some it may not. So it's very much a case-by-case basis, but by and large, I think the breaking point, if you just have a fear coming back, that's not sufficient.
All righty. I think that is about it, unless y'all have any further questions, you guys. I just really appreciate your expertise and helping our businesses and with the information that you've been able to share with us today. And it's been very valuable, and I really appreciate your time.
Happy to do it.
Glad to do it.
All right. Well, y'all have a blessed day, and we'll talk to you soon. Thank you so much, everybody.
Thank you so much.
Thanks, Karen.
Bye-bye.
Bye.